Welcome to today's webinar, the last in our series on resolving rural disputes. My name is Stephanie Hepburn, and with me is my colleague Elaine Brailsford. We both specialise in disputes in the rural sector and have particular expertise in dealing with crofting disputes. And due to the current lockdown, we're both broadcasting from home today and we can't see each other, so please bear with us if you experience any time lags between us speaking. Unfortunately, we can't take questions live today, but our contact details are on the screen there, and we'd be happy to take any questions via email if that would assist. So today's webinar focuses on crofting. As many of you will know, crofting is a system of landholding which is unique to Scotland and is integral to life in the Highlands and Islands and the crofting counties. It delivers a wealth of benefits to crofters and the crofting community, but can add a layer of complexity when there's a desire to develop on the land. Croft land is often ideally situated for renewable energy developments, but the basic principle of crofting law is to give the crofter security of tenure. So careful thought and attention does need to be given to the rights of individual crofters and the crofting community as a whole before any development plans are put in place. In today's webinar, we'll look at the restrictions on development under crofting law and also explore the ways in which crofted land can be dealt with to enable development, with a focus on applications both to the Crofting Commission and the Scottish Land Court in relation to resumption, schemes for development, de-crofting, Section 5.3 agreements and reserved rights. Before we start though, we do need to give a slight health warning. A croft has been described as a body of land that is surrounded by a sea of legislation, and that could not be truer. The various crofting acts that regulate crofting are complex. There are various provisions on the slides there, and today we're going to focus on the Croft of Scotland Act 1993. We'd always recommend taking specialist legal advice for each individual circumstance, and we should also say that, in the interest of time, we've not covered owner-occupied crofts in today's webinar, nor have we looked at the crofting community right to buy or compulsory purchase, but we'd obviously be happy to answer any queries on them if required.
So looking at croft and common grazings then. If there is a desire to develop land that's subject to crofting tenure, the manner in which the development can proceed really depends on the type, size and scale of the development. The views of the crofter and crofting community may also impact what actions are required to ensure that any development complies with crofting legislation. In recent years, the main developments we've seen taking place on croft land have been renewable energy projects, wind farms or hydro schemes. But we've also seen estate owners wishing to diversify by developing holiday cottages or campsites. Now, the first stage is to identify whether the development will take place on land that is crofted or on common grazing land or indeed on both. So, what is the difference? Well, legislation from 1886 provided the first definition of a croft holding, and that is on the screen there. More simplistically, the Crofting Commission, which regulates crofting, defines a croft as a relatively small agricultural land holding which is normally held in tenancy and which may or may not have buildings or a house associated with it. Common grazings are areas of land used by a number of crofters and others who hold a right to graze stock on that land. There are over 1,000 common grazings covering over 500,000 hectares across Scotland. Grazing committees are set up to manage certain aspects of the common grazings. Now, usually the landowner or occupier will be aware of the status of the land and can advise any potential developer of its status. But if not, it can be verified by consulting the Register of Crofts or the Crofting Register. Quite confusing, but these are two separate things. The Register of Crofts is a public list of crofts which contains basic information about the croft and the people associated with it. The major problem with the Register of Crofts, though, is that although it does contain information regarding the location and the extent of the croft, it's not map-based and it doesn't contain boundary information. Now, this causes a problem when making an application to remove land from crofting tenure to allow development to proceed, because it requires a map to be included to identify the land being removed. The crofting register, on the other hand, is a public register of crofts, common grazings and land held run rig. The crofting register is map-based, showing the defined extent of registered subjects on the OS map. Registration of new crofts is compulsory, but many existing crofts are not yet on the crofting register, and they'll only be added if a certain trigger event takes place. Resumption and de-crofting are examples of trigger events.
When a development is proposed on crofted or common grazing land, the next stage is to consider how the crofter's interest will be dealt with to allow the development to proceed. We'll now look briefly at the main options that are on the slide there, and then we'll explore them in more detail and consider the legal test with reference to some real-life scenarios where we've had to advise which method is most appropriate and the advantages and disadvantages of each. Looking firstly at resumption, resumption is under Section 20 of the 1993 Act. A landlord may apply to the Land Court for its approval to resume a croft or part of a croft or the common grazings. The effect of resumption is to remove the resumed area from the control of the crofting legislation. The land is fully restored to the landowner's control, who is then free to develop it himself or enter into arrangements with third parties to allow them to occupy the land. Resumption will bind successors to the croft, so any new crofters that might inherit or otherwise occupy the croft are still bound by the original resumption order. De-crofting also has the effect of removing the land from crofting control. Sections 24 and 25 of the 1993 Act set out a number of situations that allow for applications to the Crofting Commission, so it's not the Land Court in this situation, for a de-crofting direction, each requiring the croft to be vacant. So we can see then that de-crofting is not possible if you have a crofting tenant in occupation. If the application is successful, the land is taken entirely out of crofting control, so the landowner can enter into agreements with third parties to develop the land.
Looking now at other possible ways to deal with crofted and common grazings land. Since 2007, schemes for development can be utilised for development projects on croft land. Like resumption, an application must be made to the Land Court, this time under Section 19A of the 1993 Act. The scheme is binding on the landowner, any member of the crofting community in the area affected by the development, the crofters themselves, the holder of any grazing rights, and their successors. Two widely known Section 19A applications were in relation to the Viking wind farm in Shetland and the Koigach wind farm north of Ullapool. The crucial difference between resumption and schemes for development is that under resumption, the land to be used for development is temporarily removed from crofting tenure. However, under schemes for development, the rights of the crofters in relation to the land are suspended for the lifetime of the development, but there is no change to the status of the land as croft. Under Section 5.3 of the 1993 Act, a crofter may enter into any agreement, for example with a landowner or a third-party developer, which deprives him of certain rights under the Act. Now, these rights are the right to assign the croft, the rights of purchase, the right to share in the value of land resumed by the landlord, and the right to share in the value of land taken compulsorily. Section 5.3 agreements are binding on successors to the crofter's interest. This may mean that it's only binding future tenants of the croft, and it will not be binding on a crofter who buys the croft and occupies then as an owner. A crofter cannot contract out of certain rights in the Act itself, including the right to buy their croft, so this does not negate the risk of each crofter exercising their rights to buy and then selling onto someone else upon whom the Section 5.3 agreement would not be binding. Unless, of course, in the Section 5.3 agreement, the crofter is taken to be bound if he buys and is under an obligation to ensure that any future buyer would, in turn, be bound by the agreement. Paragraph 11 of Schedule 2 of the 1993 Act obliges the crofters to permit the landowner or any person authorised by the landowner to enter upon the croft for the purpose of exercising the rights set out in paragraph 11. And paragraph 11E includes the opening or making of roads, fences, drains and watercourses. This right is subject to the landowner paying the crofter's compensation in respect of any damage occasioned.
So we're now going to turn to look at these methods for dealing with crofted and common grazing land in the context of 5 real-life scenarios we've had to advise on recently. Looking firstly at scenario 1, we were approached by a client who owned a large estate, and an area of the estate had been crofted for many years. But in recent times, one of the crofts had fallen vacant, and our client wanted to build a small house on that croft land. Because the croft is vacant, this is a situation that is suitable for a de-crofting direction to remove the land from crofting control so the client could build the house, obviously only if he got planning permission. Looking at the legal test for de-crofting, there are a number of different situations where the landowner can apply for a de-crofting direction when the croft is vacant, and the 5 of them are on the screen there. Each has its own procedure, but the one that's relevant for our client's purpose was the second one that I've put in bold on the slide. And that's set out in section 24, subsection 3 of the 1993 Act. That is, the croft was simply vacant and had been for some time. Where situation 2 applies, legislation provides that the crofting commission may grant the de-crofting direction. The applicant, in our case, our client in this case, must satisfy the commission that the croft will be used for or in connection with some reasonable purpose, and the onus was on our client to satisfy the commission of this. What is a reasonable purpose is the same as resumption, which we'll discuss later, and the reasonable purpose must be in relation to the good of the croft or the estate, or to the interests of the crofting community, and the land must not be excessive for that purpose. The building of dwellings is listed in the 1993 Act as a reasonable purpose. In our client's case, the area to be decrofted was a very small area of the estate, and we were able to demonstrate there was no prejudice to the interests of the other crofters or the crofting community. We lodged supporting statements from other crofters, which helped. And what also helped is that our client had planning permission already in place for the house before the application was made. Whilst you can apply for a de-crofting direction before planning is obtained, as long as the application has been submitted to the planning authority, it may be hard to demonstrate you can satisfy the reasonable purpose test without the grant of planning. In a case back in 1991, the Hastings against the Crofters Commission number 2, the applicant sought a de-crofting direction to build 2 houses, but her application for planning was refused. The Commission therefore refused her application for de-crofting, and she appealed to the Land Court, who held that, as planning had been refused, the reasonable purpose test, the building of dwellings in this case, could not proceed, and her appeal was therefore refused. So Elaine is now going to say a quick word about the procedure for making a de-crofting application.
As our client's croft was not registered in the crofting register, we had to make an application for first registration. Now you have 6 months from the date of the de-crofting application to make this, but the practice is to make it at the same time as the de-crofting application so that you don't forget about it. It can run in tandem. The Commission is required to advertise all applications for de-crofting, except in relation to applications made in respect of the 4th and 5th situation on the slide. And it must fix a hearing if requested to by the applicant. The Commission can impose conditions in the direction, and ours directed the purpose for which de-crofting was given. This controls the use to which the land can be put. We couldn't therefore use the land for any other purpose than to build a house. Conditions can be modified, so if at a later date our client decided he wanted to demolish his new house and build and use the land for, let's say, a renewable energy project, he would have to seek a modification to the condition. As we'll see, renewable energy is listed as a reasonable purpose, but you would still need to satisfy the Commission that the purpose is for the good of the estate or crofting community. Once a decision has been issued by the Commission, there's a 42-day appeal period, when any party with an interest can challenge the decision by appealing to the Land Court. Now, they must show that the de-crofting could have a detrimental effect on them. De-crofted land can be re-registered as croft, effectively an application to bring the land back into crofting tenure. And this is exactly the same procedure as applying to the Commission to create a new croft.
Looking at our second real-life scenario, one of our landowner clients wanted to build a number of holiday homes on his crofted and common grazing land. The crofts weren't vacant, so de-crofting wasn't an option. Our advice was this situation was appropriate for resumption. A Section 19A scheme for development wasn't, in our view, appropriate here because, as we'll see and as Elaine's mentioned, this would not remove the land from crofting control. Crofters' rights are only suspended with a 19A development. Our client's project was a permanent one, and therefore he wanted the land to be removed from crofting control. The legal test for resumption, an application for resumption is made to the Land Court. As I mentioned, it's under Section 20 of the 1993 Act, and that sets out the legal test that must be satisfied before the Land Court will authorise the resumption. The first hurdle for our client was to establish the resumption was for a reasonable purpose, and Section 20, subsection 3, sets out a non-exhaustive list of reasonable purposes, and those are on the slide there. You'll see it includes the building of dwellings, the generation of energy, and any other purpose likely to provide employment for crofters and others in the locality. In a 1959 case, Mackay's Trustees against Coltart, the Land Court held that the fact the purpose for which the landlord intends to resume is listed, it was a previous Crofting Act, but nowadays it would be the 1993 Act, does not of itself mean the purpose is reasonable, requiring the application to be granted automatically. The Land Court has to be satisfied itself the test is met, notwithstanding the purpose is listed in the legislation. In our case, we didn't have the consent of the crofters in advance, but even if the client had agreed the consent of the crofters in advance, that also does not mean the application will be granted automatically. The court must still be satisfied the purpose is reasonable, having regard to the good of the croft, the good of the estate, the public interest, and the interest of the crofting community in the locality of the croft. The Land Court has authorised resumption for a wide variety of purposes, not just the obvious ones like renewable energy and the erection of dwellings. Whilst every case does turn its own facts and circumstances, I've set out some examples on the slide there of when the court has authorised resumption for a particular purpose. And these have included applications for the creation of allotments, quarries, guided missile ranges, for planting trees, for a fish farm shore base, for a golf clubhouse, the building of a marina and a car park, for stables and paddocks as accommodation for horses, and also to enable a landlord to grant a right of occupancy to a squatter. In our case, our application, which was drafted by Sir Crispin Agnew QC, we argued the resumption will be for the good of the estate because it was going to restore an unused ruin on the common grazings and also provide the estate with an income from holiday lettings. Work will be provided for a builder in the local community, which was in the public interest. Families coming to the cottage for holidays would also provide a benefit for the crofting community in the locality of a croft. They would spend money in the community, for example. We also referred to the local development plan and the community council plan, both of which had the growth of the local economy through tourism as its object. Because the client had planning permission in advance, we were able to refer to this in the application. Elaine will now say a brief word about compensation and procedure in the context of resumption.
The Land Court is entitled to order adequate compensation to be paid to the affected crofters, and that's in terms of Section 21. Compensation is for agricultural loss, It's often negligible and normally assessed by the court and agreed to by parties as being nil. It must be distinguished from any share in the value of the area of ground. In addition to compensation for agricultural loss, a crofter under Section 21(1) is also entitled to a share in the value of the land resumed. The legislation provides that shall be 1/2 of the difference between the market value of the land, less any compensation, and the crofting value. The relevant date for valuation is the date of resumption. The court may have to assess market value, which is a sum equal to the amount which the land is sold, if sold on the open market to a willing seller, might be expected to realise, and that's Section 21(2). Crofting value is to be determined by the court as such amount as the court may determine to be the proportion attributable to the land resumed of the current rent payable for the croft, such amount being multiplied by a factor of 15. It's often agreed at nil. In many resumptions, agreement on the resumption and its terms, including compensation and share in market value, is reached with the crofter before any application is made. This is often given effect to in a Section 5(3) agreement, which we will come on to later. In our case, this wasn't possible, but valuations were instructed, and we stated in the application that the compensation that our client was offering, and the valuation was lodged with the application. Now, the application was made to the Land Court, and as we shall see in relation to renewables, it's common that the developer's legal team make the application in the name of the landowner with the landowner's consent. The application for resumption must be notified to the Crofting Commission, and even if the application is unopposed by the crofters, the Commission may still object. The Land Court cannot authorise the resumption unless an application to register the croft is made within 6 months of the date of the application to the Land Court for resumption. And I've mentioned that the common practice is to make that application for first registration at the same time as making the resumption application. The Land Court may attach conditions to the resumption order. A standard condition requires the resumed land to be secured with stock-proof fencing to protect remaining croft land.
Well, in our case, the application was opposed by the majority of the crofters affected, as well as the Common Grazings Committee. We lodged letters of support from the Scottish Crofting Federation and the local community council. Unfortunately, our client's planning permission lapsed during the Land Court process, and his application to renew the planning permission, which was in exactly the same terms as the original, was refused. This meant the application to the Land Court had no prospects, as the reasonable purpose test could not be satisfied. Whilst our client could have appealed the refusal to renew the planning, there was no appetite for a further battle with the crofters, and so the application for resumption was withdrawn in this case. Looking now at scenario 3, last year a renewable energy client approached us because they wanted to develop a small-scale hydroelectric project on common grazing land on an estate on the west coast. Planning had already been obtained, and there were 6 crofters, each having different shares in the common grazings were affected, but they all consented to the development and compensation had been agreed in advance. So what options were available to this client, Elaine?
Well, de-crofting wasn't an option because there was no vacant croft. Resumption was an option, as was a Section 19A scheme for development. The hydro scheme was a relatively small-scale development though, and while Section 19A schemes for development are becoming more common, and it is entirely possible to use them for smaller scale projects, their use still tends to be for that larger scale development involving multiple interested parties, rather than the smaller projects such as this one. Now, clearly all developments should be looked at independently on their own merits, and every client will have its own objective. The developer client in this particular case wanted the certainty that the land would be removed entirely from crofting control. So the client decided to proceed by way of resumption and a Section 5(3) agreement. This is one of the main advantages to resumption. The land is fully restored to the landowner's control, so this control could be passed to the developer in terms of the lease. Stephanie, what other advantages do you think resumption has?
Well, in this case, another advantage was the agreement had been reached with the crofters already in relation to compensation and also about the conditions to be attached to the resumption and the crofters' share of the development value. This enabled the application process to be commenced more quickly than with a scheme for development, because in this case, no scheme was in place and would have to have been drawn up. It also meant it was less likely the Land Court would call a hearing, which would keep costs down. The Land Court has the power to authorise a resumption for a specified period of time, referred to as temporary resumption. The length of the hydro scheme in this case was anticipated to be 40 years, so temporary resumption for 40 years was sought from the Land Court. The period for temporary resumption can be extended on the application of the landowner. One difficulty that arose in this case was that the Land Court prefers to have a start date for the resumption. It won't issue resumption retrospectively, and its normal practice is to authorise resumption forthwith, unless asked to authorise it from a particular date. In this particular case, the lease was conditional upon the resumption being authorised by the Land Court, so there was no date of entry until the resumption was approved. This meant we could only seek resumption for 40 years from the as-yet unascertained date of entry in terms of the lease. We discussed this approach with the Land Court in advance of making the application, who confirmed that approach was competent. We've mentioned the legal test for resumption. Elaine, can you tell us more about that in practice in this case?
Well, Section 23A(8) specifically lists renewable energy as a reasonable purpose, but we still had to demonstrate that that purpose was for the good of the croft, the estate, or to the public interest or the crofting community. We argued that the project would increase the generation of energy by renewable means and would generate economic activity, which was both in the public interest and the interest of the crofting communities. Our client had also committed to an annual payment to a community benefit fund so that local communities would benefit from the hydro scheme. The agreement reached with the crofters deprived them of certain rights that they would have been entitled to under the 93 Act in terms of compensation, as the agreement reached with the crofters was different than what was provided for in the Act. As such, this agreement had to be approved by the Land Court in terms of Section 5(3) of the 93 Act. And so we also sought this approval from the Land Court. Now, this is a good example of how Section 5(3) agreements can work alongside resumption applications. Section 5(3) agreements are often used in order to facilitate access and investigatory work prior to development taking place. Even when agreement has been reached with the crofters, a hearing may still be required in order for the Land Court to address the question of reasonable purpose and valuation. It's the function of the court to decide these issues, notwithstanding any agreement between the parties, and it's still at the discretion of the Land Court to refuse the application if the reasonable purpose test is not satisfied.
Well, in this case, our application was approved, and at the end of the temporary resumption period or any extension, the resumed area will be restored to crofting tenure. We should say the timescale for objections to an application for resumption are not set out in the 1993 Act and are at the discretion of the Land Court. In practice, 4 weeks is given. Before we move on from resumption, I wanted to pick up on applications where there's no planning permission in place. Sometimes a developer does not want to incur the costs of a full planning application, particularly for a large-scale development, when there's no guarantee the court will authorise the resumption because the planning process can be quite costly. The Land Court will process an application for resumption which does not have planning. It will issue an interim order that indicates whether the purpose was a reasonable one or not. The application would then be suspended, that means paused, until planning is granted, and the court would then issue its formal order authorising the resumption. Looking now then at scenario 4, a renewable energy developer client wishes to develop a large-scale wind farm on crofted and common grazing land and has funding in place and an agreement with the landowner to do this. The development has got multiple interested parties. Our experience is that certain funders have expressed doubts about lending on the basis of a scheme for development, as the land remains subject to crofting controls, with the crofters still retaining an interest in the land. So there's a lack of vacant possession being obtained. Funders, in our experience, do tend to favour resumption, as this has the benefit of removing the land from crofting tenure and vacant possession is achieved for the period of resumption. We are, however, seeing more acceptance of funding for schemes for development in relation to wind farm developments and other renewable energy developments, particularly larger scale ones. And in this particular case, the funder was content to proceed by way of a scheme for development. Elaine, can you tell us about some of the advantages with schemes for development?
Well, one advantage is that it can include restrictions on the crofter's rights in respect of certain contiguous or adjacent land, as well as the development site itself, in order to secure the operation of the development. So, for example, the scheme may provide that the crofters cannot graze on the land included in the scheme, or that they can't cut peat or grow trees. Resumption would deal only with these restrictions insofar as the resumed area is concerned, which might be restricted to just the footprint of the turbines and not in relation to the wider site. Another advantage is that if approved, the consent to develop in accordance with the scheme is likely to last for the length of the development. The land remains under crofting tenure so that when the development finishes, it is a temporary one. If it's a temporary one, that is, then the land reverts to its original crofting use when the scheme finishes. There's no issue about resuming the land temporarily for 40 years and then seeking an extension if the lease for the site is renewed. The scheme for development is binding on the landowner, any member of the crofting community in the area affected by the development, the crofters themselves, the holder of any grazing rights, and their successors. Another benefit is that the developer can make the application itself with the consent of the landowner, thus avoiding agents acting for the landowner at the behest of the developer, as you have with resumption. The application should not trigger registration in the crofting register. If the Land Court approves the scheme, the Crofting Commission enters that into the Register of Crofts.
Well, depending on the situation, there can be disadvantages with a scheme for development as well. A perceived downside is that any application must be publicly notified. The Commission or any other interested party can object to the scheme on the grounds that it does not meet the legal test. And that's a wider class of potential objectors than you have with resumptions. If there are objections, the Land Court must hear these before reaching a decision on the scheme. There must be a detailed scheme appended to the application or intimation detailing how that land will be developed and what the recompense will be involved. The 1993 Act makes no provisions for amendment once the application is made. The developer needs to be satisfied at the outset that the scheme is adequate, which means all the groundwork is done at the start to ensure the scheme is correct, which can be a costly exercise, as it may involve carrying out costly investigations, albeit if planning is in place, it's likely that investigation will already have been done. It also implies there will be substantial discussion with the crofters to ensure the scheme works. The scheme will need to contain, amongst other things, clear plans, details of the timetable and method of construction of the proposed development, details of the date of commissioning the development, including different phases, the lifetime that's proposed for the development. Also should be included in the scheme a statement of the expected total cost of the development and the method of securing the finance, and a statement of the profits that have been projected to come from the development. There's obviously a lot more than would be required for a resumption application. In our client's case, it was decided to go with the Section 19A scheme for development. So, Elaine, can you tell us about the legal test we had to satisfy then?
Well, under Section 19A1 of the 93 Act, the landowner or someone acting with the landowner's consent, such as a developer, can apply to the Land Court for its consent to the croft land being developed in accordance with a scheme of development, and intimate that every person with rights in or over that croft land has consented to the development. Whether you proceed down A or B, consent to an application will not be given unless the court is satisfied, firstly, that the development is for a reasonable purpose, and this means the same as it would mean in the context of resumption, which, as we've seen, includes the generation of energy. It's to carry it out would not be unfair, essentially that it would have no significant adverse consequences for a member of the crofting community that are disproportionately greater than the benefits of the scheme, which would bring to the rest of the community. The scheme provides for there to be fair recompense to each member of the crofting community affected by the development, that the community would be likely to benefit financially, and such benefit would be at least commensurate with any financial benefit which the members of that community might obtain on the development proceeding by other means, and the development as one that would be likely to bring benefits to the community at least as much as it would do if resumption took place. Any objectors would need to show that the proposed development does not meet these criteria.
We've touched on the procedure when looking at the advantages and disadvantages, but just for completeness, we would note that Section 19A provides that objections to a scheme for development must be made in writing within 28 days of public notification being given. In our scenario, consent was given without a hearing and the scheme for development approved. Turning lastly to scenario 5 then, we were approached last year because a renewable energy developer client was developing a renewable energy project on the estate. The land on which the development was taking place was not crofted, but the access road to the development was situated on a land that was subject to crofting tenure. The development was being funded by a third-party funder. Agreements were in place with the landowner and the crofters to proceed to resume the crofted land, but we were asked to consider whether any other options were appropriate. We looked at the reserved rights under Schedule 2 of the 1993 Act that we mentioned at the start of the webinar, but our view was this route was not appropriate in the circumstances, and especially in a situation where the crofter's consent had already been obtained to other methods of securing rights to the land, which give far greater certainty. The reserved right is a general right for the landowner, and whilst there are a number of authorities in this area, it's unclear whether that right could be relied upon to grant rights to third parties to access land for development, such as wind farms. There have been cases where a reserved right was relied on, but the crofter later challenged the use of the access road because of noise, nuisance, damage to land, etc. Developers and funders therefore tend not to rely upon this general reserved right due to the concern that either the crofters or any subsequent crofters would challenge the use.
We also considered Section 19A schemes for development, and we've already discussed the advantages and disadvantages of these. Although an access road to a wind farm, and thus a road serving a wind farm, is likely to be considered a reasonable purpose, as the road is necessary for the generation of energy, and the legislation that brought in Section 19A was brought in with renewable energy projects in mind, it was not intended, though, by legislation that a scheme for development would be used in this situation. We therefore advised that resumption, coupled with a Section 5.3 agreement to make provision for compensation, would give greater certainty, and that's the normal industry practice where consent of the crofters has already been obtained.
Well, that concludes today's webinar. Thank you very much for joining us. I think we were a little bit over time there. I'm sorry just for the time delays between Elaine and I speaking. We'd be more than happy to take any questions via email, and both of our email addresses are on the slide there. And if you do have any suggestions for future webinars, please don't hesitate to get in touch. We'd always welcome any suggestions. Thank you very much.
Thank you.